Testing, 1, 2. Di- Testing, 1, 2.
Hello, Jeremiah.
Hello, yes, this is Warren.
Yes, sir. Are you calling in for the sound check?
Yes.
Okay. You go ahead.
Testing, 1, 2. Testing, 1, 2.
Sounds good, sir.
Okay, and I believe Pamela Dunstan is also on the line.
She is.
Okay.
Hi, I'm back in my office.
Hi, Pam.
Hi, Warren.
Yes.
Yes. So, operator, how does that sound to you? Both of our lines.
It sounds fine.
Okay, that's great. So I'm going to mute my phone, and we're going to leave the main line open. So if anybody uh, rings and tries to let them know that their voice is live in the meeting room.
Yes, ma'am. Understood.
Thank you so much.
You're welcome.
Hi, Travis. This is Pam. Do we have anybody in the sub conference?
No, ma'am.
No? Okay, thank you.
You're welcome.
Joining Michael Yockey.
Thank you.
Hello, Pam. Is Miss Lehman? Is she going to be dialing in, or will she be in the room in the main speaker line with Jeremiah? Or is she dialing in separate?
I'm sorry. You talking about the chair?
Yes.
No, this is the chair's line.
Perfect. Okay. Okay.
Thank you.
You're welcome.
joining Melanie.
Nalani.
Thank you. I'm sorry. Ma'am, what SAC are you with?
I'm sorry, I'm with Hawaii.
Hawaii. Thank you, ma'am.
I'm with
Welcome.
I'm with South Dakota.
South Dakota, great. Thank you. And I'm
Joining
looking
David
for,
Cladney.
thank you. Is the Nebraska SAC on?
Excuse me, this is the operator. We have a Jonathan Benjamin Alvarado saying that they are a presenter.
And I'm sorry, can you give me that name again?
Yes, Jonathan Benjamin Alvarado.
Okay, and are you with the Nebraska SAC?
Yes, I am.
Okay, thank you. Oh, there you go.
This meeting of the U.S. Commission on Civil Rights comes to order at 12 p.m. on September 13, 2019. The meeting takes place at the Commission's headquarters located at 1331 Pennsylvania Avenue Northwest, Washington, D.C. I'm Chair Catherine Lehman, and the Commissioners...
Excuse me, Chair. We have not opened the lines.
Oh, so I should stop running through all of this?
This was just a test run to show that she can do it.
Everything sounded great, ma'am.
Thank you very much. Really kind of you.
Okay, if you would just count to, say 5 and then begin, okay?
Okay.
All right.
So now, are we beginning?
Yes, ma'am, go ahead.
Okay, terrific. This meeting of the U.S. Commission on Civil Rights comes to order at 12:01 p.m. on September 13, 2019. The meeting takes place at the Commission's headquarters located at 1331 Pennsylvania Avenue Northwest, Washington, D.C. I'm Chair Catherine Lehman. The commissioners who are present at this meeting, in addition to me, are Vice Chair Timmons Goodson, Commissioner Adegbile, Commissioner Harriet, and Commissioner Narasaki. And I understand we have some commissioners on the phone. If you could confirm you're on the line when I say your name. I believe we have Commissioner Cladney.
Yes.
Thank you. Commissioner Yaki.
Confirmed.
Thank you. Is Commissioner Kirsnow on the line?
Yes.
Thank you. Terrific. A quorum of the commissioners is present. I see that the court reporter is present. And Mr. Staff Director, are you present?
I am.
Thank you. The meeting now comes to order. Is there a motion to approve the agenda for this business meeting?
So moved.
Thank you. Is there a second?
I second.
Thank you. I'll begin the call for amendments with one of my own, and that is to table the presentation from our main State Advisory Committee chair until our next business meeting, and to add a presentation from our Hawaii State Advisory Committee chair. Is there a second for my amendments?
Second.
Thank you. Thank you. Are there any further amendments?
Yes. Excuse me, South Dakota's on the line as well.
Thank you. We'll call on you soon. Commissioner Yaki, do you want to go ahead?
Thank you very much, Madam Chair. I'd like to place on the agenda a motion to adjust the statutory deadlines, the report deadlines that are due on September 30th to October 1st to accommodate the Rosh Hashanah holiday.
Thank you. Is there a second?
Second.
Thank you. Any further amendments?
Yes, Madam Chair.
Commissioner Narasaki?
I'd like to amend the agenda to add a discussion and vote on a proposed letter regarding language access on the Federal Housing Finance Agency rules and applications.
Thank you. Is there a second?
Second.
Terrific. Any further amendments? Hearing none, let's vote to approve the agenda as amended. All those in favor say aye.
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 Any opposed? Any abstentions? The motion passes unanimously. We will now hear from the chair of our Hawaii Advisory Committee, Nalani Fujimori Kaina, on the committee's most recent report titled Micronesians in Hawaii, Migrant Group Faces Barriers to Equal Opportunity. Chair Fujimori Kaina, please go ahead.
Good morning. Good afternoon, everyone. It's morning here in Hawaii. Thank you for this opportunity to address the commission. Our commission started to meet in 2015 to look at the issues of discrimination against Micronesian migrants in the state of Hawaii. We had 2 hearings that were conducted to receive information from the community about the discrimination that they were seeing, both individuals from the Micronesian community as well as agencies. It's important to note that for the Micronesian migrants in Hawaii, they have a special relationship with the United States. Micronesians for us in Hawaii are one of our latest migrant groups, but they do have a unique history. Between 1946 and 1950, there were 67 nuclear tests on their islands, which resulted in the compact agreement between the United States and the Kofa Nations. The Kofa Nations include Micronesia, Marshall Islands, and Palau. Some of they are currently in the state of Hawaii. They're disproportionately homeless, unemployed, and lacking access to health care. There's also a general lack of language access services that further the discrimination against this group. In hearing our testimony, we heard from both social and institutional. We heard testimony revealing both social and institutional racism and discrimination endured by the Kofa migrants. For us, this issue was really important in that we've seen the discrimination throughout the community. The Micronesian migrants are culturally a close-knit group, and some stereotypes about this close-knit group have pervaded throughout the community and led to discrimination, especially in housing. The committee took various testimonies related to healthcare issues, housing, education, employment, and language access. I do want to highlight a few of the areas, a few of the issues that were raised in each of these areas. With regards to healthcare, Micronesian members are treated as a separate class. They're not eligible for Medicaid or other kinds of eligibility programs, and they're also limited in their access to certain types of health care. With respect to housing, we see ongoing discrimination in housing, basically because of language access and sometimes because of family size. There is also issues that we have seen and that were testified to with respect to people kicking them out and landlords treating them unfairly. With respect to education, some of the testimony that we received was heartbreaking, related to bullying by others against Micronesian students in a particular situation. One individual talked about when something went stolen, her nephew, who was Micronesian, and other kids of Micronesian descent were the only ones who had their backpacks searched. We also heard stories about equal opportunity in terms of documentation that would need to be provided, additional documentation that would have to be provided in order for them to work, and sometimes making it difficult under certain issues about retaliation. Language access continues to be an issue for this population, and ongoing issues occur partly because of the limited number of translators available in the numerous languages spoken by this population. And finally, there are issues around cultural competency and understanding some of the nuances of this community, which includes really, again, a close-knit community that really does that cannot say no, as one of our testifiers talked when they were asked to put up family members. Based on the studies and based on the testimony and information that's also available in the community about the historical relationship between COFA migrants and the United States. The committee has made a number of recommendations which are in your report. I won't detail them at this time, but I'm happy to answer any questions that the Commission has.
Thank you so much, Chair. I'll open for questions from my fellow commissioners. Commissioner Arasaki?
Yes, I want to thank the Hawaii State Advisory Committee for taking up this very important topic. This is a group of people who are much ignored and pretty much totally invisible in Washington, D.C., and often get caught up in the anti-immigrant legislation that happens. When lines are drawn between citizens and non-citizens, people forget the special status that these migrants have. And the reason that they have them is because of the important role that their islands play in our national security, as well as the historic damage that the U.S. did to those islands and their ability to survive with the nuclear testing on those islands. So I think it's time that this come to light. I'm wondering if in one of your recommendations that you would make, should the Commission itself consider taking up this topic and looking at how well the various agencies of the federal government are treating these people in the way they provide services, as well as their enforcement of anti-discrimination on the basis of national origin.
I think the committee would be more than happy if the Commission were to take this up. I think, just to echo on your comments, one of the things that is so interesting about this group is that they fall into this category that's basically called non-immigrant group, which is kind of this strange category that is it's almost less than immigrant, yet it is special. It is more special than someone coming in that doesn't have a relationship. And I think, the treatment of this group, especially because of their special status, is one that really needs to be taken a look at. And also, I think the other side of this, which I think the report doesn't capture as much as I think we hope to, is also the contributions of this population. It's not just discrimination. It's not just not being able to get access to public assistance, but they are contributing and trying to contribute, and and are working in our community. And so I think that's the other side of this, and making sure that they aren't subject to discrimination in that they are trying to contribute to our economy.
I have one more question. I was very much struck by the report noting the fact that people from Micronesia actually have among the highest per capita military recruitment for the U.S. military when compared to other states, and that once enlisted, this group is 5 times more likely to die in combat compared to the U.S. average. Yet after risking their lives, they have trouble being able to access care from the VA facility for which they're eligible. And I wanted to make sure that I am understanding this correctly, that as a veteran of the U.S. military, when living in the United States, they're not afforded the full benefits of a U.S. citizen. Is there any efforts that's been made by members of Congress to fix that, if that's true?
Not that I can think of off of the top of my head. I mean, again, this group is not eligible for, the certain paths to citizenship. They're also not eligible for. Sorry, I just lost my train of thought. But yeah, that they're not eligible for certain paths of citizenship because of the way in which they come into this country.
So the very least is one thing that Congress might consider is making people who serve in our military eligible for citizenship, at the very least, I would think. Thank you.
Yeah.
Other questions? Commissioner Degway?
Have there been efforts to work with the representatives from Hawaii to sort of look into the need for greater resources, for the federal government to provide greater resources for this population?
Yeah, I mean, I think there have been numerous. I mean, the congressional delegation in Hawaii is well aware of the issues, especially the impact, the financial impact on the state of Hawaii. I think the most recent effort, and I do want to point out that just within the last couple of weeks, I think recommendation 8 for the in our report has actually been addressed through advocacy done by by Senator Hirono and others in the community. So the rule was recently changed with respect to access to a real ID. So there have been some movements in this area, and the congressional delegation again is well aware of of many of the issues that are being raised in this brief.
Sorry, could you just state again what was the nature of the rule change?
Okay, so in number 8, it was related to access to the Real ID. The rule was changed so that you had to have a passport and visa in order to qualify for the Real ID Act. COFO migrants actually don't have a visa. So when they travel into the United States, they don't actually receive a visa document, so they couldn't meet that requirement, which is part of the requirement in what the rules say for getting access to this. So they were being required to get an employment authorization document, which was another document that was allowed under the rules in order to get the Real ID Act. The rules have since been amended to allow them to only have to show their passport, and I think their I-94, and I can't, or one other document that they actually have. So the real issue was that they were asking for a document that didn't exist for this population in the rule change, in the initial rule, but the rule change has corrected that problem.
Thank you.
Thank you. I will just join Commissioner Narasaki's appreciation for the breadth and depth of the report. It was eye-opening on a topic that I did not know well and that felt to me painfully timely now as we are seeing national consideration of restriction and eligibility for non-citizens and the particular harms that the report details and the prescient expectation that these harms would come to pass decades ago that we now live was devastating to see, and I appreciate the thoroughness and the depth of the report. I had a question at page 27 in the summary section of the testimony. The report mentions testimony from a person from the University of Hawaii Office of Multicultural Student Services who testified that FAS citizens pay a tuition rate that is 50% higher than other residents, and I wondered if that's a statutory requirement or how that comes to be, that these students who are eligible to be in Hawaii and are resident in Hawaii are having to pay so much more tuition. Do you know?
I do not remember off the top of my head, and we would have to do a little bit more research to find out exactly what the basis for that was. I know that one of the issues that was raised that is not part of this report is the fact that Micronesian students are not eligible for financial aid, which may also contribute to some of these issues. But I would need to look more closely into exactly what she was referring to.
Okay. Thank you. Well, just thank you again for the information and the careful and thorough documentation in the report. Are there other questions from fellow commissioners? Okay. Hearing none, Chair, I will thank you again for taking your time to present to us today and for your service and leadership on the Hawaii SAC. Thank you very much.
Thank you so much. Have a good day. Bye-bye.
You too. Next, we'll hear from our Nebraska Advisory Committee's members, Jonathan Benjamin Alvarado and Judy Gashkibos, on the committee's statement regarding the use of Native American Indian mascots in non-Native public schools.
Good afternoon, and thank you very much for this opportunity. I'm not sure my colleague is online right now, but I wanted just to take this moment to thank you for entertaining our statement regarding the use of Native American Indian mascots in non-Native public schools. This came about because of an initiative that was launched by the Nebraska State Tribal Relations Committee, where they introduced a resolution to the state legislature calling on senators to examine the replacement of Native American mascots in non-tribal schools. The resolution actually calls for members of the Education Committee to study the issue and report their findings. The committee has not acted yet, and this statement is offered in support of their effort to move this issue along, knowing full well that there will be significant pushback here in the state of Nebraska. As a matter of fact, this past week in the statewide newspaper, the Omaha World Herald, there was an article that really kind of talked about the insistence of a community in rural Nebraska of holding on to their Native American mascot in the face of what we now know as nationwide kind of efforts to have those types of mascots eliminated. And so that was really the genesis of our effort, and we're really happy to have the opportunity to provide the statement to the U.S. Commission on Civil Rights regarding the use of those mascot names.
Thank you very much. I'll open for questions, and I'll start with one of my own. I appreciate your explanation of how it came to be that the State Advisory Committee is offering the statement, and I'm interested to hear the evidence that you took in or the information that you relied on to draw the conclusion, as you note in your statement, that it is the conclusion of the Commission as well that Native American mascots are harmful and should not be used in schools. And so I share the view, and I'm interested to hear about the information that your State Advisory Committee took in.
Right. Well, what we did is we looked at the kind of the historical arc of how this all came to be, noting that twice the Nebraska Commission on Indian Affairs in 1991 and then again in 2008 issued resolutions that asked the schools to cease with the use of Native American Indian images, names, and mascots. And then additionally, the State Department of Education, the Nebraska School Activities Association have issued guidance. They haven't gone as far as to issue bans on the use of mascots. And there have been incidents in the recent past where Native American communities, we have a number of tribal reservations here in the state of Nebraska, where high schools there, when they've gone to statewide tournaments and what have you, have actually been kind of discriminated on, and actually there have been incidents regarding them as individuals. And so we kind of just feel that it's an opportune moment to begin to reconsider and to look at how these are being used and the manner in which it continues to, inflict harm on those communities as they are.
Thank you. In my last life, when I was enforcing federal civil rights at the Department of Education, I had the painful opportunity to hear from Native American students about their experience in schools where Native American mascots were in use, and how distressing it was for them to try to learn every day in school in that context. And I imagine I will never forget the tears and the harm that they expressed. So I just say my personal thanks to you for leading the State Advisory Committee to make the statement and to shed light on that harm.
What we will be doing in response to the statement itself is that we're going to continue to monitor the initiative as it passes through the Nebraska State Legislature's Committee on Education, and to encourage senators to advance legislation that would finally eradicate or eliminate the use of those mascot names moving forward. I happen to be an administrator at the University of Nebraska at Omaha, and we, until 1971, had a Native American mascot, and we were one of the very first universities in the United States to change the name and to recognize, the harm that it was committing on the Native American community. And so there is precedent in the state of Nebraska. We're just hoping that the public schools will follow in our wake.
Thank you. Commissioner Arasaki, you had a question?
I just wanted to add my thanks to the State Advisory Committee. As you well know, the Commission completed I think it was like 3-year study before we issued a very lengthy set of recommendations and assessment of the federal responsibilities to the Native American community. And during that time, the chair and I and other commissioners did a lot of traveling, and this is an issue along with the bullying and hate crimes that occur committed against Native Americans that came up often. So very happy to see that you have taken a position and are working hard to try to make change in Nebraska.
Thank you.
We appreciate that, and we will continue work.
Madam Vice Chair?
Yes. I'm just curious, around the nation we are, especially in the South, we are currently experiencing a great deal of debate about Confederate statutes. And I'm wondering that in the face of the testimony that you've received regarding the hostile educational environment that's created in the face of these depictions, What is the defense or explanation? With regard to the Confederate monuments, we hear that it's about heritage. Um, what defense or reason of explanation is offered?
What we've discovered is that there's just a recalcitrance and almost a kind of very vulgar type of response to the initiative. In the media, they've actually gone to the use of expletives, saying that the efforts is a bunch of, and you can leap to your imagination what that is like. And it's unfortunate because they do say that it's part of the community's heritage, that this has been the mascot since the high school was created. It's a matter of pride and expression of their heritage with the families and race. They see it as a tribute and not as an insult to the Native American communities. And they've gone as far in those communities to identify 14 and 15-year-old Native American heritage individuals who, are in support because they like to name themselves personally. But I don't think that, that's legitimate in terms of the reasons as to why they want to, keep it. And then when pressed by the media, they really couldn't provide any evidence as to, because they made a statement to the effect that they actually went to a tribe and asked for permission to use the name, but there's no evidence to support any of that. And so that's where it is right now. I anticipate that the effort is not going to go without some controversy as we move forward here in Nebraska, but I think it's high time that we have the discussion.
Thank you.
So with that, I think if there are no further questions, we'll move on to the next item on our agenda. And thank you, Mr. Benjamin Alvarado, for your leadership on the State Advisory Committee. Thank you very much for taking the time to speak today. Next, we'll hear from Gay Kingman of our South Dakota Advisory Committee on the committee's summary of briefings on subtle racism in South Dakota. Ms. Kingman.
Thank you. This is an opportunity to join you this morning, and I know you have a full agenda, so I'll try to be brief. The South Dakota Advisory Council, I have to say we identify with Nebraska and what they're doing there because we find a lot of similar things here. We're rural states. We have a significant Indian population in South Dakota, and so our children a lot of times face a lot of racism. We held 3 briefings, and I know you've read the memo in front of you, but I'd like to focus on the subtle racism that we chose, because we have both subtle and blatant racism in South Dakota for our people. And the American Indian tribes are political entities in the United States. They sign treaties with the United States government. So they're more than race, it's more than a minority issue. We are political issues, and that's been upheld by the United States courts. So when our people face racism in anything, it's also political, and of course a violation of the civil rights. But a couple of things I wanted to point out that we couldn't go into detail in the report. One is the misunderstanding or the not knowledgeable about this political relationship. Indians are getting a handout or this kind of thing. But in our treaties, those were due us. And our children face this when they go to school. So there's a lot of racism in the schools. Our people tend to be in poverty situations. According to the U.S. Census, we have one of the highest counties here with the highest poverty rates. So there's a lot going on, not only the racism, but the poverty racism. And we have racism with law enforcement. And it's one of the studies that we did as a commission was to look at the use of cameras, which turned out for us, were favorable on the use of cameras because it does shed the light on what's happening with law enforcement if they're being videotaped or cameras on their treatment. And so we were, that was a good research, and we were happy with that. There's economic racism that came up. We had reports from two business people from one the Pine Ridge Reservation and the other the Rosebud Reservation. Now these are successful businesses today. One's construction and the other is a finance business. But they told how many times they had applied for loans or applied for grants and they were denied. And these were top-notch applications. And these were also applications to minority programs to get funded, and they were overlooked. And so finally there was a breakthrough after, I forget, like 12 applications or so over the years, and they began getting them. But there's a misunderstanding about funding on the reservations, that you can't go on there, you can't collect, or the finances are good, or they're not doing, they're not accountable. There's all that kind of racism for, I guess, economic racism, when you call it, and that was testified to by the two successful Indian businessmen on the reservations. We find also the religious racism because many people are traditional and they have certain religious practices, and those are always put down or not adhered to or not understood. And so these are some of the things that came out. We found blatant racism, buses, the schools stopping the bus routes through certain Indian neighborhoods, whereas they continued in other areas. We found discrimination on not allowing the Lakota anthem, national anthem, to be sung. Certain things that happened with our children. And then one of the things we'd like to do, the Great Plains has requested a hearing on the U.S. Commission on Civil Rights report, Broken Promises. And we were very happy to see that Broken Promises report come out of the commission. And so we've asked the U.S. Congress to follow up with some hearings on that to hopefully continue and maybe shed some light of day on what's happening, continuing to happen with this Broken Promises report today. And finally, I guess you've probably seen in the media about the Murdered Missing Indian Women effort that's going on. Law enforcement isn't paying attention to anytime an Indian person goes missing, and there's no data collection. And so right now there's a bill in Congress to try to remedy that. But that's a big issue, a problem for us in the states that have Indian reservations. There's a lot of our people that go missing, and nobody pays any attention. The press, we never have press covering any of the things about American Indians. We don't get the New York Times or anything like that out here. So that in itself, too, is another form of violation of civil rights. And then lastly, I would like to invite the Commission to South Dakota so you can see for yourself, our conditions. I know I've lived in Washington, D.C. for many years, and out here you have vast areas of land. We have the last areas of prairie grass left in the United States. And so our conditions are totally different. And so to understand where we're coming from and where the American Indian reservations are, the federally recognized tribes that are treaty tribes, and the conditions we have, And I would really like to invite you out, and I know the tribal chairman would like to have you come out. We would like to extend that invitation. So in brief, that's kind of what I wanted to say today, that some of the things that weren't we weren't able to get into the report, and I would answer any questions you have.
Thank you so much, Ms. Kingman. I will say I had the pleasure to join the third day of the briefing that you all held in Pierre, and I know that Commissioner Narasaki joined the second day at the Pine Ridge Reservation. Commissioner
Yeah.
Narasaki will, I'm sure, speak for herself, but I will say for myself that I thought that the briefing was incredibly impactful and compelling, and that you all took in deeply moving testimony about the urgency of the felt need for change and reform, and the kinds of ways that the state is trying to make progress and the areas in which it is making progress, as well as searing need for better recognition of civil rights for all present in South Dakota.
Yeah.
So I will, I carry that testimony with me as I think about the rest of the work that we do. I'm very pleased to hear you mention the Broken Promises report, about which we are thrilled, and that incorporated significant testimony from the South Dakota Advisory Committee briefing. So I was very grateful to be able to rely on that information in our ultimate reporting as well. And I appreciate your taking the time today to share with the Commission some of the information that didn't make it into the summary of the briefing itself. Commissioner Arasaki?
Yes, thank you, Madam Chair. I did have the honor of being able to be present at the second hearing, and I want to acknowledge the hard work of our staff who support the state advisory committees and help work with all of you to hold these very important hearings. One of the things that stayed with me most at that hearing was, in fact, the public testimony by several women about the missing women and children who have been ignored because of the lack of resources that the federal government is providing, so that there could be enough law enforcement and tribal courts and the ability for the tribes themselves to be able to enforce their laws and protect their citizens. So I hope that when you looked at Broken Promises, you in fact saw several of the items that came up during your hearing reflected in the report. One of them was, in fact, a lot of the chapter on economic development came from my experience and the things that I heard during that hearing. So these SAC hearings are extremely important. We take them very seriously, and they're extremely helpful to our ability to really understand the issues that we're moving forward. I'm very excited that Congressman Holland and Senator Warren have in fact taken up our report and reduced many of the recommendations into legislative language. And I will be leaving the commission at the end of this year, but I hope the commission will continue to work with Congress as they try to move forward and correct some of the problems that we reported on, and hopefully put forward some thoughtful recommendations about what can be done.
Thank you. Other questions or comments from fellow commissioners? Terrific. With that, Ms. Kingman, thank you very much for taking your time today and for your leadership on the South Dakota State Advisory Committee.
Thank you.
The next item on our agenda is a discussion and vote on the discovery materials that include the discovery plan, the outline, and the timeline for the Commission's project on sub-minimum wages for people with disabilities. To begin discussion, is there a motion?
Yes, Madam Chair. Dave Fladney here. I move to adopt a timeline, outline, and research plan for the sub-minimum wage project circulated to all commissioners by our Director of OCRA. I'd like to thank my fellow commissioners for approving this topic on wages paid to people with disabilities that are below the minimum wage, as is allowed under current federal law in the Federal Labor Standards Act. I think it's very important that we are looking into the oversight of this program by the Departments of Labor and Justice and evaluating the proposed changes to how and when, if ever, such wages should be permitted. I am glad that we are taking up this issue of deep significance to many people with disabilities and their families. I thank OCRE for their work already researching this topic, and I look forward to holding a briefing on November 15th of this year. We have also considered the possibility of conducting site visits following the briefing as resources and staff time allow. The proposed outline lays out a report which I believe will contribute meaningfully to the ongoing debate about the payment of subminimum wages. I appreciate your consideration and welcome our discussion on these materials. Thank you very much.
Thank you, Commissioner Cladney. Is there a second for your motion?
Second.
Terrific. So to continue discussion, I'll offer a few points. The materials presented to us for vote today reflect research from our Office of Civil Rights Evaluation, the Office of the General Counsel, and Commissioner Cladney and his special assistant, Amy Royce. I believe these materials set this investigation with a solid foundation, and I look forward to the Commission's briefing in November 2019, as well as to our eventual reporting. Is there any other discussion? Hearing none, I'll call the question, take a roll call vote. Commissioner Dagbele, how do you vote?
Aye.
Commissioner Harriet? Commissioner Kursanow?
Yes.
Commissioner Cladney?
Yes.
Commissioner Narasaki?
Yes.
Commissioner Yaki?
Aye.
Vice Chair Timmons Goodson?
Yes.
And I vote yes. The motion passes. No commissioner opposed, one commissioner abstained. All others were in favor. The next item on our agenda is an amended timeline for the Commission's project on Title IX and campus free speech. To begin discussion, I will move to approve the timeline as circulated to all commissioners in advance of this meeting. Do I have a second?
Second.
Thank you. I'll begin discussion by noting that the extensions reflected in this revised timeline were made to accommodate a request for more time from the Department of Education in their review of our draft report. As with all of our projects in which the actions of a particular agency are under review, the Commission appreciates the opportunity to work with the agency and ensure that their perspective is taken into account in our reports. Is there any further discussion? Hearing none, I'll call the question and take a roll call vote. Commissioner Dagbele, how do you vote?
Aye.
Commissioner Harriet?
I abstain.
Okay. Commissioner Kursanow?
Yes.
Commissioner Cladney?
Yes.
Commissioner Narasaki?
Yes.
Commissioner Yaki?
Aye.
Vice Chair Timmons Goodson?
Yes.
And I vote yes. The motion passes. No commissioner opposed, one commissioner abstained. All others were in favor. The next item on our amended agenda is a discussion and vote on a proposed letter to the Federal Housing Finance Agency regarding the inclusion of a language preference question on the Uniform Residential Loan application introduced by Commissioner Narasaki. Commissioner Narasaki, could you please read the letter proposed for consideration?
Yes, thank you, Madam Chair. For the sake of efficiency, I actually wasn't planning to read the text of the letter unless a member of the Commission requests I do so, because it's very long.
I'll withdraw my request.
But I'll provide a brief summary. I request that we consider the letter as circulated by my special assistant on Wednesday, September 11th at 10:37 Eastern Time a.m. The letter is addressed to the Director of the Fair Housing Finance Agency and asks that the agency reverse its decision to remove a question about language preference from the updated Uniform Residential Loan application, the form that is nearly universally used when applying for a home mortgage. During 2016 and 2017, the agency conducted a very comprehensive process to explore the possibility of adding a language preference question to the form, which included commissioning a study and a report and conducting a request for input where they received over 200 comments. In late 2017, the agency announced that the new forms would include a question asking borrowers about the preferred language. It was hailed as a step in the right direction for language access in this critically important area. Unfortunately, last month the agency announced that it was reversing the plans to include the preference question, offering no explanation whatsoever about why. The letter our letter expresses concern that the moves appears to undermine the agency's statutorily mandated duty to facilitate home ownership for underserved communities, that it did so with no opportunity for public input, and calls on the agency to reverse its decision. It also notes that the Commission has extensive experience in the area of language access and its relationship to full equality for limited English proficient communities.
Thank you, Commissioner Narasaki. Is there a second?
Second.
Thank you. Is there further discussion of this letter? Hearing none, I'll call the question and take a roll call vote. Commissioner Degbolet, how do you vote?
Aye.
Commissioner Harriet?
No.
Commissioner Kursanow?
No.
Commissioner Cladney?
Yes.
Commissioner Narasaki?
Yes.
Commissioner Yaki?
Aye.
Vice Chair Timmons-Goodson?
Yes.
And I vote yes. The motion passes. 2 commissioners opposed, no commissioner abstained, all others were in favor. Thank you, Commissioner Narasaki. The next item on our amended agenda is a discussion and vote on the statement timelines for statements that are currently due on Monday, September 30, because I am, and I think Commissioner Yaki wants to extend the deadlines to Tuesday, October 1. I am recused from the Immigration Detention Project, so I'll handle the gavel over to the Vice Chair for this agenda item.
Thank you very much. To begin the discussion, is there a formal motion?
Yes, this is Commissioner Yaki. I would like to move that due to the date of the Rosh Hashanah, that in observance and respect for our colleagues at the Commission, that the FY19 Statutory Enforcement Report and Statement deadline and the Immigration Detention Report Statement deadline, both which fall on Monday, September 30th, be extended to Tuesday, October 1st, with appropriate adjustments to the following timelines for rebuttals, if any, that are part of the process.
Thank you. Is there a second to that motion?
I second.
Having been seconded by Commissioner Narasaki, Commissioner Yaki, would you like to say something further about in the nature of discussion?
Yep.
I'm sorry, was that yep or no?
No.
Okay. All right. Thank you. Is there any other discussion? All right. Hearing none, I'll then call the question and take a roll call vote. Commissioner Degbolet, how do you vote?
Aye.
Commissioner Harriet?
Yes.
Commissioner Kursanow?
Yes.
Commissioner Cladney?
Yes.
Commissioner Narasaki?
Yes.
Commissioner Yaki?
I knew one day I would get Kursanow to vote with me on a motion I made. Aye.
All right. And I vote yes. The motion then passes. It is unanimous with our chair recused, abstained, whichever. I'll now turn the gavel back over to our chair.
Thank you. Next, we'll hear from Staff Director Mauro Morales for the monthly Staff Director's Report.
Thank you, Madam Chair. In the interest of time, I have nothing more to add that's already contained in the report. Of course, if any commissioner has a question about a specific item in the report, I'm always available to speak with you about that. I would like to take a moment just to welcome our fall interns. We have 3 right now in the Office of General Counsel. We have Susanna Gomez and Janice Jing. They're in the extern program at the GW Law Center. And with the commissioners right now serving as an intern is Ryan Kelly, and he's also from GW Law School. Welcome, and we look forward to all your assistance. So Thank you. Thank you, Madam Chair. That's all I have.
Terrific. Thank you. With that, we will take a recess until we reconvene at 2 p.m. for our scheduled speaker series, and I look forward to seeing folks back here at 2.
Hello, this is the operator. I have pulled your line from the conference. I just wanted to confirm that we are taking a quick recess and coming back in about an hour.
Yeah, can you give me just a moment? We're having a discussion now on what to do with that. Okay?
Okay.
Thank you.
Thank you.
Hi, Travis. It's Pam again. Is there anyone on the line?
No, ma'am.
Okay, thank you.
You're welcome. We now have David and Peter on the line.
Thank you.
Hello, Pam. This is the operator. I pulled your line from the conference. Just want to let you know that your line is open to the public, so begin whenever you're ready.
We will return now to the next iteration of the Commission's speaker series. This is titled Lessons of the Reconstruction Period for Today's Civil Rights Debates. I thank Vice Chair Timmons Goodson and Commissioner Degbele for suggesting this month's speaker topic and for coordinating the appearances of Professors Foner and Glimpf today. We are very grateful to have you with us. Professor Foner is the DeWitt Clinton Professor Emeritus of History at Columbia University. He's the author of over 20 books, which have won numerous awards, including the Bancroft, Pulitzer, Lincoln, and New York Historical Society prizes. I'll just show his most recent book, which I happen to have here for us. His publications have concentrated on the history of political ideology and race relations in 19th century America. Among his books are Reconstruction, America's Unfinished Revolution, 1863 through 77, The Story of Americans' Freedom, Forever Free, The Story of Emancipation and Reconstruction, and most recently, The Second Founding, How the Civil War and Reconstruction Remade the Constitution. Professor Glimpf is an associate professor in the departments of history and African. You are shaking your head, so I got that wrong.
Full professor.
I apologize. Professor Glimpf is a professor in the departments of history and African American studies at Duke University, and is also currently the John Hope Franklin Visiting Professor of American Legal History at Duke University Law School. She studies the U.S. South with a focus on 19th century social history. Professor Glimpf is the author of Out of the House of Bondage, The Transformation of the Plantation Household, and the forthcoming The Women's Fight, The Civil War's Battles for Home, Freedom, and Nation. She is currently completing a book manuscript titled Black Women and Children Refugees, A History of War and Refugee Camps in the United States. And we look forward to both presentations. We'll start with Professor Foner.
Thank you very much. Let me just say it's an honor to be invited to speak to the Commission. I'm really very happy to be here. As you mentioned, I have devoted a great deal of my academic career to studying Reconstruction, but I have to acknowledge that most Americans know very little about it. But the fact is that Reconstruction remains, in a sense, part of our lives today. Or to put it another way, key questions facing our society today are, in a way, Reconstruction questions. Who should be an American citizen? Who should have the right to vote? How to deal with terrorism, not terrorism from abroad, but homegrown terrorism of the Ku Klux Klan and other such groups during Reconstruction. Every session of the Supreme Court adjudicates cases deriving from the 14th Amendment enacted during Reconstruction. In other words, my point is you can't understand American society today without knowing something about that period a century and a half ago. Reconstruction is also a prime example of what we sometimes call the politics of history. I don't mean whether the historian is a Democrat or a Republican, but the way in which historical interpretation both reflects and helps to shape the politics of the time in which the historian is writing. For most of the 20th century, as I'm sure you know, what we call the Dunning School, after my predecessor long ago, Professor William A. Dunning, who taught at Columbia University, the Dunning School dominated historical writing and popular thinking about Reconstruction. In that view, Reconstruction was the lowest point in the whole saga of American democracy, a time of misgovernment and corruption caused by the misguided decision to grant the right to vote to African American men who, according to these scholars, were innately incapable of participating intelligently in political democracy. Despite its overt racism, this interpretation dominated historical and legal scholarship for over half a century and still exists in parts of of popular historical consciousness. The remarkable longevity of this Dunning School portrait of Reconstruction derived from the fact that it harmonized with the racial system of the United States from 1900 until the Civil Rights era of the 1960s. It had clear political lessons. Number one, it was a mistake to give black people the right to vote in Reconstruction. Therefore, the white South was justified in taking away the right to vote as it did around the turn of the century, of the 19th to 20th century. Secondly, Reconstruction was imposed on the South by Northerners. Maybe some of them even had humanitarian motives, but the result proves Northerners simply do not understand race relations in the South, and therefore the white South should resist outside calls for change in the racial system. This insistence upon the so-called horrors of Reconstruction became more and more strident as outside pressure began to grow, challenging what we call the Jim Crow system. As late as 1944, Gunnar Myrdal noted in his influential work in American Dilemma that when pressed about the black condition, white Southerners, quote, will regularly bring forward the horrors of the Reconstruction governments and what they call black domination. When the Civil Rights Revolution, sometimes called the Second Reconstruction, took place, the pillars of this old interpretation, especially its racism, fell to the ground, and Reconstruction was completely reinterpreted. Today, most historians see Reconstruction as a noble, if not entirely successful, effort to establish for the first time in American history an interracial democracy, something that did not exist elsewhere in the 19th century. It was a precursor to the modern civil rights movement. Now, we must remember to understand how important Reconstruction was in changing aspects of American life. We have to remind ourselves of the status of black Americans on the eve of the Civil War. In 1860, slavery was a powerful, economically thriving institution. It was not going away, as some people think. There were more slaves in the United States in 1860 than at any other point in our history. And slavery shaped the definition of American nationality and citizenship, giving it a powerful racial dimension. According to the Supreme Court in the Dred Scott decision, no black person could be a citizen, whether free or slave. Citizenship was for whites only. But there was another alternative vision, mostly put forward by the abolitionist movement, black and white, which had the idea of birthright citizenship for all Americans, severing citizenship from race, and with equality before the law for all of these citizens. Black political gatherings before the Civil War consciously called themselves conventions of colored citizens, challenging the dominant view that citizenship was for whites, the kind of white nationalism, that citizenship was for whites only. Now, as was kindly mentioned, my new book is coming out next week on one of the enduring legacies of the Reconstruction era, the 13th, 14th, and 15th Amendments to the Constitution. I want to briefly talk about them, even though Professor Glimpf will also be delving more deeply into the legal history of Reconstruction. The 13th Amendment, of course, irrevocably abolished the institution of slavery and introduced the word slavery for the first time into our Constitution. The founders had protected slavery in some ways, but used circumlocutions to describe it, persons held to labor or other persons, etc. But the 13th Amendment was only the beginning of the Reconstruction process. Abolitionists saw it, and many Republicans also, as what you might call, to use a modern phrase, the beginning of regime change. That's really one way we might think about Reconstruction, as an attempt at regime change, the transformation of a pro-slavery regime that dominated the United States from the Revolution until the Civil War to an anti-slavery regime grounded in the ideal of equality. Most Republicans were not abolitionists, but they all agreed on certain principles. Slavery had caused the war and the death of 750,000 Americans. Slavery had deprived its victims of the basic rights to which all persons were entitled. Slavery had done more than oppress slaves. It was a cancer that degraded white labor and threatened the essential liberties of all Americans, such as freedom of speech and freedom of the press. The 13th Amendment intended to change all of this and more. Unlike the Emancipation Proclamation of President Lincoln, it applied to the entire country and made the abolition of slavery an essential part of the nation's legal order. In one respect, it was truly revolutionary. It abolished the largest concentration of property in the United States. Slaves as property were the most valuable concentration of property in the country. That was just abolished with no monetary compensation to the owners. One congressman declared when the 13th Amendment was enacted, the one question of the age is settled. But if it resolved the fate of slavery, the abolition of slavery opened a host of other questions. What exactly was being abolished? Property in human beings, obviously. What about the racial inequality that was essential to slavery? Was that also being abolished? What would be the status of the former slaves and who would determine it? What did it mean to be a free person in post-war America? These were the questions on which the politics of Reconstruction persistently turned. White Southerners had their own answers, as became clear when Lincoln was assassinated and Andrew Johnson became president. Once lionized in the old historical interpretation as a heroic defender of the Constitution, Johnson today has a strong claim to being considered the worst president in American history. He lacked all of Lincoln's qualities of greatness. He was deeply racist. He had no sense of public opinion. He did not have the ability to work with Congress. Johnson set up new governments in the South once the war was over, controlled entirely by white Southerners. They enacted a series of laws called the Black Codes to define the freedom African Americans now enjoy. They gave blacks virtually no political or civil rights, and they tried to use the law to force African Americans back to work on the old plantations. These laws alarmed the Republican Party, which controlled Congress, into thinking that the South was trying to restore slavery in all but name. And in 1866, Congress passed, over Johnson's veto, one of the most important laws in American history, the Civil Rights Act of 1866, the first law to declare who is a free citizen of the United States and what rights they are to enjoy. The Civil Rights Act states that anybody born in the United States, except, quote, Indians not taxed, is a citizen. Birthright citizenship, this principle, is a statement that anybody can be a loyal American. Race, religion, national origin do not matter, nor does the legal status of one's parents. This measure, and then it's put into the 14th Amendment, severs citizenship from race. And as you know, that idea remains controversial to this day. The Civil Rights Act went on to declare that all these citizens must enjoy basic legal equality. It does not say anything about the right to vote. That comes later. But it guarantees equality of civil rights, specifically the rights to sign contracts, own property, testify in court, etc. These are the rights of free labor necessary to be able to compete in the economic marketplace. What's interesting in the Civil Rights Act, it says all citizens must enjoy these rights the same as enjoyed by white persons. The concept of whiteness before the Civil War was a barrier of exclusion. When states said only white men can vote, whiteness was therefore used to exclude others. But in the Civil Rights Act, whiteness becomes a baseline. If white people enjoy certain legal rights, everybody else has to enjoy those rights also. It becomes a standard for all Americans, a complete shift in the role of the concept of whiteness in our legal and political system. As I said, Andrew Johnson vetoed the Civil Rights Bill, and it became the first important law enacted over the veto of the president. And in his veto message, he denounced the law for what is today called, he didn't use this phrase, reverse discrimination. He said the distinction of race and color is made by the bill to operate in favor of the colored and against the white race. And in this idea that expanding the rights of non-whites somehow punishes or takes away something from the white majority, the ghost of Andrew Johnson still haunts our discussions of race. But of course, a law can always be repealed, and so very quickly Congress put this and other principles into the 14th Amendment, the most important change in our Constitution since the Bill of Rights. It's long, complicated. It contains many provisions which are kind of arcane today about the Confederate debt and things like that. But the heart of the 14th Amendment is the first section, which constitutionalizes the principle of birthright citizenship and goes on to bar states from abridging the privileges or immunities of citizens or denying to any person, not just citizens, citizen or alien, any person in the country, the equal protection of the law. The word equal is not in the original Constitution. Many people think, the man in the street thinks that the Constitution says all men are created equal. That's a noble idea, but it's not in the, that's in a different famous document, of course. The word equal is not in the original Constitution, except for a provision about what happens if candidates for president get an equal number of electoral votes. The 14th Amendment makes the Constitution what it is today, a vehicle through which aggrieved citizens who lack equality or feel they lack equality can take their claims to federal court. And since the language is race neutral, it does not mention black or white, in our own time, the courts have used the 14th Amendment, as you know, to expand the legal rights of many groups. Most recently, dramatically, the rights of gay men and women in this and lesbians in this country with regard to the right to marry. That was, of course, a 14th Amendment decision, the gay marriage decision. The first section of the 14th Amendment transformed Americans' relationship to our government. And the definition of citizenship, as I said. As one editor at the time said, the 14th Amendment changed a constitution for white men into one for mankind. It also marked a fundamental change in the federal system. It empowered the federal government for the first time to enforce the basic rights of American citizens. The Bill of Rights, of course, begins with the words, Congress shall make no law. It's a set of restrictions on the power of the federal government when it comes to freedom of speech, trial by jury, and our other civil liberties. Before the Civil War, the Bill of Rights only applied to the actions of the federal governments, not the states. But all three of these amendments end with a phrase that Congress shall have the power to enforce the amendment by appropriate legislation. The shift from Congress shall make no law to Congress shall have the power just symbolizes how the Reconstruction Amendments made the federal government what Charles Sumner, the senator from Massachusetts, called the custodian of freedom. The 14th Amendment said nothing directly about the right to vote, but very quickly after that, Congress decided that the government set up by Andrew Johnson needed to be set aside and mandated the creation of new ones in the South based on voting by both black men and white men, the first mass extension of the right to vote to African Americans in our history. But the 15th Amendment was limited in important ways. It denied the states the right to deprive people of the right to vote, but it did not positively create a right to vote the way many radical Republicans wanted. They wanted a positive statement that all males age 21 had the right to vote. They warned that the 15th Amendment as written would allow states attempting to deny blacks the right to vote to use provisions such as poll taxes, literacy tests, which did not mention race but could be enforced in ways that were racially discriminatory. And this, of course, is what happened in the late 19th and early 20th centuries when the South took the right to vote away from black men. But the advent of black male suffrage inaugurated the period we call radical Reconstruction, when new biracial governments came to power in the South, an unprecedented experiment in interracial democracy. These governments had many accomplishments. They created the first public school systems in Southern history, the first black colleges. They created the space in which the black church became a powerful national institution and the center of the black community. Black men held office in Reconstruction at every level of government, from the two first black United States senators to members of Congress, state legislatures, down to sheriffs, justices of the peace, school board officials, and other public servants. My estimate is that about 2,000 African American men actually held public office in the South at some point in Reconstruction. This was a revolutionary change in our political system. But of course, the problems of the emancipated slaves were not simply political. They had deep economic problems as well, coming out of slavery with no economic wherewithal. One might say that in Reconstruction, the political revolution went forward, but the economic revolution did not. But the political revolution was drastic enough to inspire, as I mentioned, a wave of terrorism in the South by the Ku Klux Klan and kindred groups designed to try to overthrow these governments. And hand in hand with that went a slow retreat on the part of the North from the ideal of equality, the Reconstruction ideal of equality. Until by 1877, the entire South was back in the control of under the control of white supremacist Democrats. And in the next generation, the system that we call Jim Crow, based on disenfranchisement of black men, a segmented labor market in which the good jobs were reserved for whites, the severe cutback in public funding of black education, all this comes into place in the generation after Reconstruction in the South. Didn't this racial system, this overtly racist racial system, violate the Reconstruction amendments? Of course, it fell to the Supreme Court to interpret those amendments, and sadly, over time, the court played a crucial role in the long retreat from the ideals of Reconstruction. The broad conception of constitutional rights with which blacks and their allies attempted to imbue the abolition of slavery proved to be tragically insecure. But in the late 19th century, an alternative rights-based constitutionalism also emerged among black activists and their allies, one that rejected the evolving Supreme Court jurisprudence which severely limited the scope of the 13th, 14th, and 15th Amendments. In my book, I talk about one such group, the Brotherhood of Liberty, a group of black lawyers and ministers and others in Baltimore who in 1889 published Justice and Jurisprudence, a large book which was the first full-scale assault on Supreme Court decisions limiting the scope of the constitutional amendments. They offered a different view of the rights that constituted the privileges and immunities of citizens, which the amendments were meant to protect. They assailed employment discrimination, housing segregation, and lack of access to education as violations of the Constitution, which the Supreme Court would never do at that time. Can a citizen, they asked, be daily excluded from the paths of industrial progress and yet be a citizen of the United States? Well, let me just conclude by saying that we have come a long way, of course, toward fulfilling the agenda of Reconstruction, and yet, in my view, the three amendments contain latent power that has never really been employed by the courts to promote the ideal, the Reconstruction ideal of racial justice. And in fact, even during the Warren Court, which dismantled the legal edifice of Jim Crow, they did not really confront the long train of decisions that restricted national power over citizens' basic rights. They were not, the justices, maybe understandably, were not willing to state that for 70 or 80 years the Supreme Court had just been wrong. My final point is this. We Americans like to think that our history is a straight line of greater and greater freedom. But actually, as Reconstruction shows, it's a more complicated story of ups and downs. Rights can be gained and rights can be taken away to be fought for another day. In some ways, that seems to have been happening in our own times. In his second inaugural address, Abraham Lincoln identified slavery as the fundamental cause of the Civil War and challenged Americans to think creatively about how to fulfill the aspirations unleashed by the destruction of slavery. And however flawed the Reconstruction era that followed the Civil War can continue to serve as an inspiration for those of us striving to achieve a more just society. So thank you very much for listening.
Thank you, Professor Foner. Professor Glinth?
Thank you. I'm quite honored to be here. Oops, okay. Thank you for inviting me, and especially Vice Chair Patricia Timmons-Goodson, who initially extended the invitation. Can you hear me okay? Okay. The war was over, and the Union was saved, but it was a far different Union. It was in some ways a new nation state in the making, and it was untested. Americans had fought each other for 4 years in a war that ended, as we know, in the defeat of Southern states that had attempted secession, and in the liberation of enslaved people, and in the establishment of the sovereignty of the federal government. Over the course of the next 10 years, powerful men, 3 presidents, Lincoln, Andrew Johnson, and Grant, well, I'm starting a little bit back, along with Republican leaders like John Bingham and Thaddeus Stevens and Charles Sumner, would debate how to forge a new nation that could be grounded in new legal, social, and political, in a new legal, social, and political order. This task was made all the more difficult because, as Frederick Douglass famously said, slavery had not died honestly. It had not died of moral conviction. It had not died from a call to humanity. It had died from political and military necessity. So much, then, depended on how the nation would incorporate 4 million enslaved people, or formerly enslaved people, and formerly free people. Congressmen debated and negotiated language. The language that would appear in the Reconstruction legislation addressing these questions. How far could they go? How far could they go, or should they go, to ensure that federal law would be enforced? Freedom, James Baldwin once stated in an interview in the 1960s, was political, an economic problem. Liberty, by contrast, is what came with liberation from slavery. 2 quite different things. As Professor Foner has noted, the Reconstruction Amendments abolished slavery. They guaranteed that all persons would have due process and equal protection of the law. They gave black men the right to vote. They established the principle of birthright citizenship and forbade states, that no state shall clause, to make or enforce any law that abridged the privileges or immunities of citizens. Taking that language almost verbatim from Article 4, Section 2 of the Constitution, and similarly the due process language of the 14th Amendment from the 5th Amendment to the Constitution, and for the first time, Congress added enforcement clauses to constitutional amendments that Professor Foner also referred to. Professor Foner and other historians and legal scholars have described what they call the Second Founding. And I want to talk a little bit about that Second Founding as it played out far from the halls of Congress, and in particular how freedom and liberty affected and changed the everyday lives of black people. In thinking through these questions, I think we should be reminded, as Barbara Fields, historian, who's a colleague of Professor Foner's, writes, that there is, quote, an immense problem when we think that when there is something profoundly unsettling in the contemplation of a change so immense in scope and purchased at such great cost, yet so ambiguous that it is impossible to say with full conviction whether it's a change for the better or for the worse. I want to say quite clearly that former enslaved people would have had no trouble answering this question despite the violence and rights problems that came after slavery. So I want to focus this morning or this afternoon a bit on the Civil Rights Bill of 1875 and the civil rights cases, and to look at the question of human dignity. In 1865, delegates to the South Carolina Constitutional Convention submitted to the people of that state what they called a Declaration of Rights and Wrongs. That declaration made a human rights claim, stating that everyone had a right to his own body and mind, that slavery was a violation of these principles of justice and humanity, which consist of personal liberty and the right to be free. It was but one of dozens of documents, one of dozens of protests in which black people declared that continued public disrespect and attacks on their personal dignity were intolerable. We could see this in Charleston, where black women like Mary Bowser protested when they were refused passage on streetcars and dragged off the cars. When Mary Rollins filed a suit against a steamer and won a judgment of $250. When black men politicians, keenly aware of the ways in which women were singled out for humiliation, protested. For example, political activist Alonzo Renzier of Charleston protested plans to segregate Charleston's newly constructed Performing Arts Center, centering his protest in the affront to his wife. He said he was not willing that his wife should be insulted till the 1st of May to oblige anyone. Northern free black people also continued to protest and to mark the assaults on their dignity and rights. In January 1866, 11 groups of black people in Pennsylvania sent petitions to the Congress of the United States, to the Committee on Judiciary, the 39th Congress, second session. That petition wrote, we, the members, this was one of the petitions rather, we, the members of America Church of Kingston, Philadelphia, most respectfully call the attention of your honorable body to the 4th article of the Constitution, in which we find that the United States shall guarantee to every state in this union a republican form of government. And knowing that in many states such a form of government does not exist, we therefore petition for the adoption of the following amendment to the Constitution, quote, that there shall be no legislation within the United States or its territories against any civilized portion of its inhabitants, native born or naturalized on account of race or color. All such legislation, the petition stated, now existing is anti-Republican in character and therefore void. I note, too, that the petitioners were majority women. There were 28 women, and the men were the 6 ruling elders and the 6 trustees. Similarly, in 1866, that same year, the North Carolina Equal Rights League called for the repeal of all laws and parts of laws that made distinctions on account of color. The passage of the Black Codes in unreconstructed southern states were designed not only to create a subjugated working class, but to force that class to endure humiliations in every corner of their lives, public and private, to vacate black people's right to a private life even. And we can see there's all kinds of examples. And so when we talk about the Reconstruction laws, one of the things that I'm interested in is seeing how this played out on the ground. And so, for example, bastardy laws have been with the world since, I guess, people started getting married and having babies or whatever. Anyway, the bastardy laws were applied to free people differently from the way in which they were applied to white people. After the Civil War, former slaveholders, of course, claimed the right to the labor of black children. And they made this claim in many, many ways. One was to gain access by arresting fathers and obliging those fathers to either give up their children or sell themselves into slavery. And they didn't say into slavery, they said to sell themselves for 1 to 7 years. The Civil Rights Act of 1866, America's first major civil rights bill, and the Act of 1883 aimed to end these sorts of practices. As Professor Foner noted, the Act of 1866 was passed over Johnson's veto. The Act of 1866 defined all persons born in the United States, again, as Professor Foner has already noted, authorized them to be able to bring cases to be heard in federal court. It honored the presumption as well that primary responsibility for the enforcement of these laws lay with the states, and that remained a problem. The Bill of 1875, of course, probably is more well known and studied. This bill was introduced in 1870 by Charles Sumner as an amendment to a general amnesty bill for former Confederates. The 1875 bill guaranteed all citizens, regardless of color, access to accommodations, theaters, public schools, churches, and cemeteries. And it also provided that all lawsuits brought under this law would be tried, importantly, in federal, not state courts. Sumner, as we know, fought hard. He did not live to see the bill when it was passed. But after his death, Congress continued to debate the bill, although it could not agree, congressmen could not agree on how far the power of the federal government should be extended. And so, out of this debate, because there were so many people who were trying to come to some kind of compromise, they finally decided to drop the most controversial provision, which was to extend or to require the desegregation of public schools. So Congress dropped the part of the bill that would have prohibited segregation in public schools. I also note that 7 African American representatives in this Congress carried the debate in favor of the bill, offering themselves personal accounts of discrimination on railroads and in restaurants. Every day my life and property are exposed and left to the mercy of others, wrote one representative from Alabama. The bill became law, as we know, in 1875, requiring that all persons in this country were entitled or shall be entitled to the full and equal enjoyment of accommodations, advantages, facilities, and so forth, regardless of race or color, and regardless of previous condition of servitude. The second provision provided that any person denied access to facilities on account of race would be entitled to monetary restitution. These bills, as we know, led to many court cases that had the effect of overturning or invalidating the Civil Rights Bill. And I want to just talk about one. We know, for example, of the importance of cases like the slaughterhouse cases in 1873 and the Cruikshank case as well. The U.S. versus Stanley case in 1883 is discussed a great deal by historians and legal scholars because with this case, the Supreme Court declared the Civil Rights Bill of 1875 unconstitutional. This case, as you know, was a consolidated case, consisted of 5 cases that came before the Supreme Court and was consolidated. In this case, which is probably one of the most important of the Supreme Court cases, the court found that the 14th Amendment granted Congress the right to regulate only the behavior of states, not private businesses, not individuals. Of course, and then therefore it foreshadowed the Plessy decision that would come a little more than a decade later. There must be a time, the court stated, when black people cease to be the special favorite of the law and instead take the rank of mere citizens. There would be no time when black people could take the rank of mere citizens. Because as black people on the ground kept protesting, that rank was not available to them. It was not available to Samuel Harrington, who wrote that he simply wanted his wife, and that a white man, John Dongle, held her as a slave. It was not available to Andrew Jackson, who wrote that he wanted his wife, and John Fairley held her as a slave. It was not available to 2 black men in Wilmington, North Carolina, who were sold into slavery in 1866 by the civil authorities in that county. It was not available, to persons, men and women, black men and women, who were acquitted, and I think this has continued relevance for our society, who were acquitted on criminal charges, but because they could not pay jail fees, were kept in jail. Some were kept in jail so long, languishing in jail so long, that they could never get out because the fees kept accumulating. They were given a choice. They could sell themselves or stay in jail. They could sell themselves for a term of years, and this was after they were freed by the 13th and the 14th Amendment. Today, we face again political challenges to birthright citizenship, to voting rights, to due process, to equal protection. And I want to say to everyday dignity. In 1950, Janet Franklin reviewed a book titled Southern Legacy. And he said of the author of that book, he, the author, decries any attempt to modify the pattern of segregation by legislation, but he fails to admit that much of the pattern is maintained solely by legislation. That still holds for much of our society today. Thank you.
Thank you very much, Professor Glimpf. I'll open for questions from my fellow commissioners and just say that these were both very powerful presentations. I appreciate your bringing us this history and also tiptoeing into its relevance today. Madam Vice Chair.
Thank you very much, Madam Chair, and to Professor Glimpf and Professor Fauner. Thank you, thank you, thank you for bringing this more than powerful information to us. I think I indicated to you, Professor Fauner, that earlier this year I did participate as a panelist in that multidisciplinary conference that was sponsored at Duke University, simply entitled Reconstruction. Professor Glimpf, you were one of the planners and organizers of that, and over that 2-day period, Reconstruction, that defining era in our American history, was critically examined in a way that I think the two of you have very well done over a much shorter span of time. But the point of the conference was for us to take a look at that period of history because in the opinion of many that appeared, that period set the stage for the civil rights movement as we know it. And it occurred to me that it's setting the stage for the work that we're doing here at the Commission. So again, thank you so much for coming. Professor Glimpf, I really appreciate you bringing the Reconstruction period to us, as you said, on the ground. Many of our citizens during the period of Reconstruction, I understand that the formerly enslaved, one of the first things that they sought to do was to bring their families back together. And you touched on it by speaking of children being retained by slave owners and forced to work. But that was what folks wanted. They simply wanted to bring their families back together. And we're witnessing at this time not only impediments to families remaining together, but as you've already pointed out, jail fees that folks are not able to pay and are required to stay in jail. Let me have you, if you will, Professor Glimpf, talk to us just a bit more about what this newfound freedom and the period of Reconstruction meant for, you've talked to us about the women and the men somewhat, but talk further about day-to-day life and what it is that the formerly enslaved folks were seeking, the modest, we would view as modest requests that they were seeking.
Certainly. Thank you for the question. I think your question gets to the heart of just fundamental, basic human life, you know, and to the question of what damage is done by systems of power that attempt to destroy people's human dignity. And I think that we are and should talk a lot about the law and how important the law is. It's incredibly important. And at the same time, understand that when the law is unfair, or the impact on people's everyday lives can be immense. And so, one could answer your question very simply in some ways by saying the reconstitution of families was central to Black people's vision of what freedom meant. It meant the right to to no longer be separated, to no longer have to see a child sold, or a husband sold, or a mother sold, and to be, a family again. And so you see, and historians have documented this incredible movement to reconstitute families after the war ends. And so when I study Reconstruction, I'm interested, one, from a legal point of view, in understanding very clearly what Congress tried to do and how the courts interpret it. But I'm also trying to understand, if you're living in some rural place in Louisiana or in my home state of South Carolina, what does this mean for ordinary people? And I think it's important to say that ordinary people were not ignorant of the law. I mean, it's very clear that they understood what the law meant, because it had been such an important and central part of their lives. It was the law that said they couldn't be taught or educated. It was the law that said their families had no right to be together, that said that they could not be legally married. So the law was just a very, very central part of their lives, even as slaves. And so when they were free, they talked about the law. They understood what the law was. They understood that what you're trying to do here, when you say that I cannot leave this plantation, that you're trying to find a way to use the legal system and the courts to keep me here. And that's what, when you keep a man or a woman in jail, because the fees keep adding up every day, they can't pay the fee. And so you give them that option: sell yourself. So I think, even without going directly to the particular questions that we face today as a society, in terms of how we treat our children and our families, that we can say that we know enough to do a better job. We know enough from our own history, and it's not just the history of African Americans. It's the history of immigrants who came from Italy and from Poland and from um, Portugal, from England even, because of course many of those immigrants from England were poor people. So we know from our own history as a nation what's important and what we need to do. We just have to do it.
Thank you.
Commissioner Dagway?
Thank you both for those powerful presentations and for your lifetime of work on these important topics. I think that there was something that I detected that was a parallel in both of your talks that I think may relate in some ways to some of the discussions we see in public policy today. Very often we hear about things that are regarded as false equivalencies, where things that are not the same are being put forth as being comparable. If I understood your talks correctly, I think that there may have been another strain of policy debate in the Reconstruction era, which was a strain of what I will call false superiority. The idea that granting equality to somebody is reducing or diminishing the state or status of somebody else. And I'm interested to have you explain, first Professor Glimpf, and then you, Professor Foner, how this concept from the civil rights cases, the term the special favorites of the laws, how through a historical lens we are to understand those words in that Supreme Court decision at a time when the people who are being spoken of, many of them have the literal physical bonds of slavery on their bodies. And so I'm trying to understand what those words meant at that time and how you regard it as having carried through um, our history.
I I'm hesitating because it's at once a question that seems to have again an easy answer and one that doesn't. For me, your question, and thank you, Commissioner, for it, uh, can be sort of rephrased as what is the purpose of white supremacy? Uh, what work does it intend to do? And it it would seem on the surface to make no sense at all to be fearful of former slaves or to be fearful today of immigrants, um, except if that ideology is in itself flawed. And so, as I tell myself when I'm trying to work through difficult historical questions, I have to always be careful to distinguish between what's history and what's ideology and the history of ideology, right? So I think that there's no rational answer to your question. Um, uh, it's the only answer that I can think of has to do with the value um, of white supremacy, uh, and I don't know if that makes sense.
It does. Thank you.
Just to add to Professor Glim's comment, in the civil rights cases where that phrase it was used by the majority that black people have to stop being the special favorites of the law, John Marshall Harlan, the great dissenter, dissented in that case and pointed out that white Americans had actually been the special favorites of the law throughout the entire period from the Revolution up to the Civil War. The institution of slavery requires all sorts of laws which elevate whites among blacks, giving, let's say, any white person the power to apprehend any black person, whether free or slave, to demand identification, passes, proof of freedom if they're out on the road, etc. Um, and that now you didn't need laws now to protect the right. Now that slavery was over, white people still did not need laws protecting their status. The status was inherited, their wealth, etc., from slavery. But that the effort to uplift the former slaves and give them a basic, modicum of equality was threatening to the idea of white supremacy and to the powers that many white people had long felt they had a right to exercise over black people. It's not surprising that after 250 years of slavery, these ideas of racial inequality were deeply, deeply embedded in the culture, and not simply in the South, of course, in the North as well. That's why Reconstruction is so remarkable. It's astonishing that within a couple of years of the end of slavery, laws were passed, amendments were passed, trying to create uh, a genuine baseline of equality for all Americans, regardless of race. Um, Maybe the astonishing thing is not that Reconstruction didn't succeed, but that it was attempted at all under the historical circumstances. And it is unique. No other country that abolished slavery went through a period such as Reconstruction, in which African Americans were empowered so quickly politically after the end of slavery. So, it naturally generated a great deal of resistance. Unfortunately, in our history and in the history of other countries, some people's sense of their own equality is predicated on somehow denying equality to others, and it's very hard to overcome that sentiment.
I think it's interesting in part because very often we see debates about civil rights statutes. Sometimes those debates are framed in the context of whether they have run their course or achieved their purpose. And if you come to those debates without the benefit of the historical perspective that you're sharing with us today, you might take that question as a good faith question being put in the time frame in which the case is presenting itself. But sometimes if you look at it through a historical lens, you come to understand that the question has been asked since before these very measures were put in place, and as you have explained, sometimes advanced against the amendments to the Constitution that would later create these amendments. So understanding the context in which the arguments are advanced perhaps causes you to look at the question through a different lens. One more question for you, if you would be willing, Professor Fooner.
Of course.
I'm thinking about the relationship between courts and historians. You shared with us some perspectives on some of the Supreme Court's jurisprudence in the Reconstruction era and where that took us. It's interesting that that through jurisprudence we look at legal rules and we look at holdings, sometimes, but perhaps often, divorced from the historical context of those rulings. We look to the rule and we use the rule. We cite the precedent in a different context. History, as I understand it, is an undertaking to understand human, structural, and temporal events to better illuminate where we have been. There was an author of a book called The Day Freedom Died about the Cruikshank case. Who told me once that he wrote that book because the Supreme Court in the modern era cited Cruikshank.
Right.
And he was jarred by the citation to Cruikshank, and it was his feeling that people did not know the circumstances of that case or what that case was about. And so he was jarred to see a modern Supreme Court citing the Cruikshank case. Now, through a lawyer's perspective or a judge's perspective, perhaps that's not unusual for the reason I mentioned, that we look to legal rules and precedents. From his perspective, he thought that it was jarring to cite that case. And so I'm asking you, from the historian's perspective, how do we make sense of the craft of lawyering and judging where cases emerge in a particular historical context that is meaningful, but when we cite those cases and when we live by the decided case, we sometimes strip away the historical context. So I'm wondering if you could help us understand what that looks like through a historian's eyes.
Well, I am not a lawyer, although
I'm not a historian.
I have many. Some of my best friends are lawyers. I'm not a law professor, but I think it is very important for those in the law, whether they're practicing law, adjudicating cases on courts, to have a deep understanding of the history that surrounded these amendments, the laws, the previous decisions. I became interested in this particular piece of Reconstruction because, in a similar way, because I was shocked when I started investigating this for how long the Supreme Court and other federal courts cited works of the Dunning School as which are completely repudiated by historians today, and yet those works still pop up, not now, but into the 1960s and even the 70s. They pop up in court decisions when these courts want to make a historical reference. So my first point is, if judges want to cite history, they should cite current history, modern history, up-to-date history, not history that has been pretty much repudiated by the historical profession. But I also think it's important for those thinking about the law and the origins to do what Professor Glimp just did briefly, and to look outside the realm where laws are created. Look outside the Congress that wrote these amendments. These issues were debated up and down the society in Reconstruction. The meaning of the 14th Amendment, the 15th Amendment, was worked out in a sort of a mass constitutionalism, actually. It was one of the few times in American history when constitutional issues were the subject of popular debate, popular discussion, popular disagreement, etc. And I think to gain a better understanding of what these um, laws and amendments were meant to accomplish, one has to look way beyond it. For example, the views of African Americans, Professor Glimp eloquently cited them, but are very rarely mentioned in Supreme Court cases or legal arguments that rely on the 13th, 14th, or 15th Amendments, because, African Americans were outside the political system when the 13th and 14th Amendments were written and ratified, and so they don't seem to count. But in fact, their initiatives and their demands help to put on the agenda many of these principles: birthright, citizenship, equality before the law, national power to protect the rights of citizens. And so that's why I mentioned the Brotherhood of Liberty. No one's heard of them, but that's an important group putting forward a different jurisprudence than the Supreme Court actually was putting forth at that time, and yet I think more accurately grounded in the historical record than the decisions that the Supreme Court was bringing down, such as the civil rights cases and Cruikshank and many others one could cite. So I guess one could just simply say that lawyers and judges need to know more history. And our job as historians is to try to make that history as accessible as possible to them.
Thanks. Commissioner Arasaki?
Hi. I just spent last week in Montgomery, Alabama, and had the opportunity to spend several hours at the new Peace and Justice Museum and the really deeply powerful memorial. And I'm originally from the Pacific Northwest, so to me, the South and lynching seems very historical and theoretical, and I think my experience is probably like most Americans, right? That we don't have a sense of how long slavery was going. To us, lynching seems like that was more a few violent incidents and not the hundreds and thousands of women and children and men who were horribly tortured and lynched, or the fact that people would bring their kids and have picnics to watch this, that this was so widely accepted, is just very hard for me to even begin to wrap my mind around. You both made references to the fact that slavery ended not because there was a moral movement and widespread acceptance, or at least this is what I'm interpreting what you said, so that it ended in a way that somehow left things unresolved in terms of where we were, in terms of our understanding about race and racial superiority and what equality would mean. Is that why you feel like the courts turned their back on Reconstruction and slid backwards in time, and sort of got in the way of the progress that had been made in terms of really trying to get to the democracy that our founders said we were trying to achieve? What is it that will get us past that history? Because I feel like we're repeating it again. We just had a recent report come out that documented the facts that blacks have to wait in longer lines to vote, and it's because of decisions made to close polling places in black neighborhoods. There's a powerful movie that just came out about what was happening in Georgia, where there were voting machines left in warehouses while blacks were waiting 10 hours to vote. How do we get past that? What are the lessons that you draw from Reconstruction, from the history, and from what the courts did? How do we move this current Supreme Court and the courts we have today to get to a place where we can actually get to the democracy that I like to think most Americans really want us to have?
Well, I think that was a very eloquently stated question. It's often said that the Supreme Court follows the election returns. That is to say that the court decisions reflect a broader societal set of developments, not simply legal arguments and precedents, etc. Personally, I think that's not actually what happened in the late 19th century. I think that the commitment to Reconstruction actually continued longer on the part of the Republican Party officials and Republican Party voters, black and white, than the court sort of took into account. You have to look at sort of who these people were, what their backgrounds were. They were all educated before the Civil War, even though most of them were Northerners. They were educated in a legal system which emphasized the power of the states, not the federal government. They were educated in a legal system shot through with racism in one form or another. Very few of them had any connection with African Americans at all. There are a few exceptions. The most radical of them was John Marshall Harlem, who had the only one who had owned slaves actually before the war. He was from Kentucky, but their social connections were all with the upper crust of Northern society, and I don't think they were well situated to actually kind of work through the full implications for our society of the abolition of slavery and the imperatives that came out of the abolition of slavery to create a more just and interracial society. To quote something that Justice Sotomayor said at a conference I attended in her remarks, judges have to get out more. It's not a legal doctrine, but a very good point. Judges need to get out more because they need to know what's going on in society. And, as I try to indicate, once you get a few of these decisions, they become lasting precedents. And in a judicial, environment in which cases build on past precedents by and large, that's why it's shocking that Cruikshank can still be cited, because then you can't get beyond the mistakes that are embedded in Cruikshank and the civil rights cases, etc. So, I would endorse, of course, your point, basically, that we as a society, not just judges or lawyers or commissioners, but as a society, have to try to muster the commitment to understand that this is still a serious problem facing our society of racial justice, and to think about ways to, address it in a robust manner.
I would just add to what Professor Foner said. Going back to the first part of your question, I think that Reconstruction, during that moment, there was very little room for the notion that we're all equal. Very little room for the concept of equality, even though it's in the Constitution now that black people are citizens and have the right to vote and so forth. On the ground, the vast majority of Americans do not see people of African descent as equal. Now, I can understand that position at that time because for hundreds of years they've been told that. And they've seen black people in a very, very unequal position as enslaved people. What is harder today is to understand notions or ideas of racism, or because we're no longer in that moment, and I can't explain or don't know what it is that keeps people tied to ideas that don't even have complete relevance for today. I went to Montgomery myself, and even though I'm a historian, I was still very stirred and moved by that museum and the monument to the past. And in class, I teach a class on the Civil War, and in my class yesterday, we were just getting to the beginning, to Manassas and Bull Run, and at the end of the class, I asked my students what they found most compelling about what we had talked about or knew, and one student said, well, I never thought about death. I never thought about men on the battlefield losing their limbs and there being no way to help them but to just chop it off. One student said, I never thought about what uh, uh, what happened to enslaved people in that particular moment in 1861. So my students are hungry for knowledge about the past, and I don't think they're unique. So we have to, as historians, do a better job, lawyers and you all, um, because we can't, there's nothing we can do about the way you cite um, in your court decisions, right? The way judges cite, the citation preferences that don't have to at all um, be relevant to the particular case at hand, as in Cruikshank. So education remains fundamental and important, and we certainly need to put more resources there.
Thank you. I would be delighted to sit and listen to you all day, but I want to be respectful of your time since we had promised you that we would release you 11 minutes ago. So I just want to thank you again for your incredibly powerful presentations and to say to you, Professor Foner, I was very taken by your noting what Charles Sumner had said about the Reconstruction Amendments, making the federal government the custodian of freedom. It is the charge, the statutory charge of the Commission to evaluate how well the federal government fulfills that charge to be the custodian of freedom, and for us to monitor the status of civil rights and report on that status today. And Professor Glimpf, when you referred to the damage done by systems of power that attempt to damage human dignity, it's a reminder of just how important that task is. So thank you both for grounding us in history and reminding us of our charge going forward.
Thank you.
Thank you very much.
And with that, this meeting is hereby adjourned at 3:13 Eastern Time.